Elizabeth Rutan-Ram et al. Versus Tennessee Department of Children's Services et al.
All right, counsel, you are welcome to present your argument. Let me remind you that each side has a total of 15 minutes for argument. The appellant has the right to reserve up to 5 of those 15 minutes for rebuttal. So after you've introduced yourself, please let us know how much time to reserve, and the clock will be programmed accordingly. Good morning.
Good morning. May it please the court. Gabby Heibel for plaintiffs' appellants. I would like to reserve 3 minutes for rebuttal.
3 minutes, certainly.
Yes. This case arose after a state-funded agency refused to serve the Rutan-Rams simply because they are Jewish. Now, this court has to answer only one question. Are the courthouse doors open to the Rutan-Rams so that they may challenge the state-funded religious discrimination? The answer must be yes, but the court below said no. I'll address why the court was wrong in 2 parts. First, I'll explain why the Rutan-Rams have direct standing. And second, I'll explain why all of the plaintiffs here have taxpayer standing. At the outset, the purpose of standing is to ensure that the plaintiffs have a personal stake in the litigation. All of the plaintiffs do here. Starting with direct standing for the Rutan-Rams, they satisfy all 3 elements: injury, causation, and redressability. Starting with injury. The requirement is satisfied because the Rutan-Rams have suffered both a practical and a stigmatic injury. Contrary to the trial court's ruling, the Rutan-Rams didn't...
Let's talk about the practical aspect of that. My understanding is the Rutan-Rams have to be recertified in May or June of this year. Will they need to have services that would be provided by one of the agencies the state pays or provides funding to, or DCS as part of that recertification?
Yes, they're being served by DCS, and they will get recertified by DCS if that's the option that's available to them. They could, at the end, between August and November of this year, they are likely to either adopt their current foster child or she'll be returned to her biological parents. At that point, they will look to start fostering and adopting a second child, at which point they would like to consider changing the agency that they work with.
There seems to be some dispute, counsel, in terms of just how likely that is or conditional that is with regard to fostering a second child. Based on the complaint, how likely is this that the Rutan-Rams are going to try to foster a second child where they would need additional services?
They have every intention of fostering a second child. As we say in our complaint, they plan to foster a second child. And that was certainly enough in Susan B. Anthony, where the nonprofit planned to post new signage at the next election. That was sufficient to satisfy the intention requirement for standing purposes, and that's absolutely at least the Rutan-Rams have at least met that standard here. The trial court.
They were denied services, and then they were given the services by DCS. So is there still an injury where what they wanted has been received?
There's absolutely still an injury. In Hargett, the Tennessee Supreme Court said that plaintiffs need not have a franchise wholly denied in order to suffer an injury. Here, the Rutan-Rams have fewer options than their Christian neighbors when they're looking for state-funded foster care services. And on top of that, the services that they're receiving are of a lesser quality. That's true for 2 separate reasons. Part of it is that DCS is understaffed and under-resourced. This is an ongoing service that they're receiving from DCS. It's not like they get the child and then they stop receiving services from DCS. It's ongoing communication with social workers, supervision, assistance. And right now, the quality of services that they're receiving are of lesser quality than they would have received from Holston. And on top of that, Holston was an ideal organization for them for a specific reason. That's that Holston has a group care facility, and that means that children who are placed in foster care might sometimes first be at the group care facility on Holston's campus, which allows staff at the group care facility to develop a relationship with children, which they can then use to help foster parents ease the transition of that child into the foster parent's home. So not only do the Rutan-Rams have fewer services, but the services that they are accessing are of a lesser quality.
Now that was alleged in your complaint, right?
Yes.
And so we have to take that as true because this was a motion to dismiss.
Yes, that is correct. On top of the practical injury, there's also the stigmatic harm of being turned away from a state-funded agency because they're Jewish. Certainly, this court would not tell a Black woman who is turned away from a restaurant simply because she's Black or disabled that she hasn't suffered an injury because she can go across the street and eat lunch elsewhere. The same is true here. This injury is also caused by the department's funding of Holston. The causation requirement is not onerous. All it requires is that the harm be fairly traceable to the action that is being challenged in the case. Here, Holston would not be funded and denying service to the Rutan-Rams if it weren't for the challenged act here. That's true because the contract prohibits discrimination in the provision of services, and the Tennessee Human Rights Act prohibits places of public accommodation, including places like Holston, which receive state funds from discrimination.
Holston had signed that contract prior to this enactment from the legislature that you're challenging in this case. They had signed an agreement with the state saying they wouldn't discriminate. Is that correct?
Yes. The panel majority held that the causation element was unsatisfied for two reasons, but both are wrong. First, the trial court focused too narrowly on the Rutan-Rams' efforts to foster and adopt the Florida child, but that ignores the fact that the Rutan-Rams are current foster parents who are currently fostering a child and are currently receiving lesser and narrower services. The Rutan-Rams don't need to go back to Holston and again be turned away. The Sixth Circuit in May said that plaintiffs don't need to engage in futile action in order to satisfy the standing requirements. And certainly going back to Holston would be futile here, where Holston has turned them away, not specific to the Florida child, but said, we do not serve Jews. Second, Holston has on their website a statement that they do not serve Jews. And third, Holston has filed a federal lawsuit asking to continue being able to discriminate in its provision of services.
Now, the first instance dealt with the plaintiff seeking a child from Florida.
Yes.
And the argument, as I understand it, was there was no Tennessee money involved in the services that Holston would produce there. Is that accurate?
We don't dispute that.
Okay, then if no state money is going there, what's the state's involvement?
The state's involvement is that right now, the Rutan-Rams are continuing to foster, and they're fostering Tennessee children, and they have decided, after they were turned away for the child in Florida, they decided to focus their fostering efforts on Tennessee children, and any child that they foster or adopt in Tennessee will be, that whole process will be funded by Tennessee dollars.
So the Florida child is irrelevant to your arguments?
The Florida child was the moment in which Holston informed the Rutan-Rams, we won't serve you because you are Jewish.
Right.
So it's one piece of evidence that the Rutan-Rams can't get service at Holston. Holston said clearly, we will not serve you because you're Jewish, and that continues to be the case, and we know that because of the website and the federal case.
So your argument, let me just understand, your argument is that once Holston said, we don't serve you, then they got the services from the state, and they'll need services in the future. Those future services are not possible from Holston anyway because Holston has already said that they will not serve you. So that's the causation?
That's part of the causation. They look out on the landscape of available services, and those services are narrower than the services that are available to their neighbors who do abide by Holston's Christian statement of faith. And so right now, they're currently existing in a system where they have fewer services, and those services aren't up to the standards that they might have been if they were at Holston. And quickly turning to the final argument that the panel majority made to reject the causation argument, the panel majority said that there was no causation here because the challenged act allows for the state to fund a hypothetical Jewish agency that would serve only Jews. But that does nothing to address the stigmatic harm that the Rutan-Ram suffer. Their harm isn't minimized by simply knowing that their Christian or Sikh or Buddhist neighbors also might experience the same discrimination. The answer to discrimination cannot be more discrimination.
Counsel, I wonder if you could speak to how CPA 13121 impacts how high the hurdles are in terms of injury in fact, causation, and redressability. What does 13121 do to the height of those hurdles in terms of establishing standing?
First of all, we believe that the Rutan-Rams have standing based on the traditional standing factors. So 13121 isn't necessary to give the Rutan-Ram standing, but it does show that the legislature wants Tennessee residents to be able to come into court and challenge unlawful use of their taxpayer dollars and unlawful action by the state government. And so it's just an added emphasis on the fact that they have to be able to come into court and challenge discrimination that they experience with their own taxpayer dollars at a state-funded agency. Quickly, turning to taxpayer standing, Tennessee courts have expressed a desire to balance the various interests at stake when it comes to taxpayer standing. That's both the taxpayer's right to challenge unlawful action and also the court's concern with not having frivolous litigation that might hamper the government's ability to do its job or overwhelm the court's docket. And so in order to protect all of those interests, it has imposed a three-part test. All of the taxpayer plaintiffs satisfy those three parts here. They pay taxes, specifically sales, gasoline, and motor vehicle taxes. They allege a specific illegality, specifically a violation of the state constitution, and they have made a prior demand. At the very least, the Rutan-Ram satisfy the traditional taxpayer standing requirement because they have been specifically harmed by the state's funding. The state slices and dices the record and ignores the purpose of standing. But I want to be clear about what's really going on here. The state argues that a Jewish couple that was turned away from a state-funded agency simply because they are Jewish aren't allowed to enter the courthouse and challenge that discrimination. That can't be the case. Thank you.
Thank you, Ms. Heibel. We'll hear from you further on rebuttal. We'll now hear from the state. Good morning.
Good morning, Your Honor, and may it please the court. My name is Reed Smith, and I'm here with Trent Merriweather, and we represent the Department of Children's Services and the Commissioner Nichols. The appellants were talking a lot about discrimination, but again, what they're challenging in this case is state funding. The Rutan-Rams have asked the court to find that Tennessee Code annotated 36-1147 violates their constitutional rights by permitting state funding of child-placing agencies. The panel majority correctly found that the Rutan-Rams lacked any of the three irreducible minimum elements of standing. They lack a concrete and particularized injury, they lack causation, and they lack redressability.
Well, they were turned down by your agency. Isn't that a concrete event?
They were not turned down for state-funded services. In fact, they have received all of the state-funded.
Will they be turned down for future state-funded services?
Well, that would be a future question, Your Honor. And are you saying your bylaws or whatever you wish to call statement of faith may or may not be the same next time they apply to you? Well, actually, Your Honor, to be clear, we represent the state. We don't represent Holston. So
well, I recognize that, but we're talking about Holston.
Right.
That they are the state actor, if you want to put that in quotation marks, and they're the ones who denied service. Right. So you fund them. Will they continue denying services?
Well, the question as to future injury, Your Honor, is as to whether the Rutan-Rams will ever seek a fostering placement in the future that would implicate the act.
They state pretty definitely that they do.
They actually do not, Your Honor. They came up here and they said that they will foster a child in the future. But it's not any foster placement would implicate the state funding and not every state funded.
This is a Rule 12 motion, so you're saying we can't read from that lengthy complaint that they have an intent to foster another child and to adopt?
Well, actually, Your Honor, they actually specifically they specifically only say that they would give consideration to adopting a child from a private agency. And even for that, they would give consideration to adopting a child or fostering a child that would be subject to state-funded services. It's not that they would. It's that at some point, well into the future, they will give consideration to that. The Tennessee courts have made clear, especially where a plaintiff is challenging the constitutionality of a statute, that the court should not reach that question unless it's absolutely necessary to establish the present rights of the parties. Most recently,
your argument seems to set a bit of a vice here. If the Rutan-Rams wait too long to file, they end up with a mootness issue, and as happened with the child out of Florida. And if they file too soon, then they have a ripeness problem in terms of it hasn't come to fruition yet. And it seems like we're creating a very, very narrow window for them to be able to have standing, to be able to bring a suit to challenge this policy.
Not at all, Your Honor. As far as that goes, if they had come to Holston and asked for state-funded services, then I think that would at least satisfy part of the requirements here. But I think that there are two issues here. The first is any questions of placement. Any questions of placement are moot because they have a child that they're working directly with the Department of Children's Services. So any question as to a placement service is moot, and the court can't issue any additional relief.
Isn't it capable of repetition?
Well, that's again, though, for first of all, that has to be for capable of repetition and evading review, it would have to be that they could never bring a case in the future that would allow them to bring suit at that time.
General, I'm trying to understand what 13121 does in the Tennessee Code with regard to standing analysis in the state of Tennessee. Affected seems to be the key word in the statutory provision, and affected doesn't candidly sound like much of a hurdle to have to jump over. Why haven't the Rutan-Rams been affected? And they're trying to make decisions about fostering. They're trying to make decisions about what service provider they're going to use. They've already lost the ability to foster one child as a result of being, in part, in connection with being denied services. How are they not affected?
Well, Your Honor, the Florida child would have had nothing to do with the act. So I don't think that it's fair to say they lost an opportunity because of the act. Under your question about affected, though the Supreme Court has made clear that under the Tennessee Declaratory Judgment Act, which also uses the term affected, that it's not enough to allege some hypothetical future injury, which I think is the only type of injury we are looking at here with respect to the state-funded services.
Why doesn't the contract make this pretty definite? And Holston signed a contract saying they wouldn't discriminate. The state passes a law that provides for funding for entities that do discriminate based on their religious beliefs. And then Holston says, we're going to not provide you services. That looks like an incredibly strong case of causation and redressability given the nature of the contract they signed and the inconsistent subsequent action.
Well, Your Honor, first of all, the contract only runs to services provided to children in the state. It doesn't run to
But those are the services we're talking about now, General, right? Services to children in the state of Tennessee. And we're no longer talking about Florida. We're now talking about Tennessee children. And they signed a contract saying they weren't going to discriminate.
Right.
The state passes a law, and now they're discriminating.
Well, and second, to your point, I would say they have to satisfy all three elements of standing. If they fail to meet any one of those aspects, they don't have standing in this case.
One more question about Florida, because I'm hung up on it. Florida would pay for everything that Holston did, the home visits, etc., and that's why there's no standing to sue the state, Tennessee?
Well,
is that your point?
Well, Your Honor, the main point is there's no state funding. They're challenging an act on the basis that it provides state funding to agencies, and that they say they're being denied state-funded services. Those services that they sought with respect to the Florida child are not state-funded services that would be subject to this.
Well, that's what I was asking. Is my chair went down? Sorry. Does Florida pay for the home visit and everything? And is that laid out in the record? I mean, you're saying the state of Tennessee doesn't give a penny to Holston that Holston uses in regard to the Florida child? That's
correct, Your Honor. That's under the Interstate Compact on the Placement of Children. That's listed in the record. It's Tennessee Code annotated 374201, Article 5A. It says the sending agency shall retain jurisdiction over the child with respect to all matters related to custody, supervision, care, treatment. The sending agency would be an agency in Florida.
Does it say money? Does it say payment?
It says in all matters.
Payment's a matter?
Well, again, Your Honor, the other
payment doesn't sound like the list that you read, so I was just curious.
Well, the other thing to remember, Your Honor, is that the plaintiffs have the burden to establish standing. The only state-funded services that they pointed to here are the contract with Holston. The contract with Holston is specifically in connection to children who are in the custody of the state. The child in Florida is not in the custody of the state.
So no state money could be spent in that regard?
There's nothing in the record to establish that there would have been state money. And they've
anything in the record that says there wouldn't be?
Yes, Your Honor. They conceded in their pleadings that wouldn't be paid for by Florida.
I have a taxpayer standing related question. You make the argument that taxpayer standing isn't applicable essentially to state expenditures. Is there any Tennessee case that actually holds that taxpayer standing does not apply to the state, only applies to locality as the holding of the case?
I don't know if you can say that there is a case that has addressed that directly, but what I can tell you, Your Honor, is that Fannin versus the City of Lafayette is one of many cases in which Tennessee has said that the state of Tennessee does not recognize taxpayer standing. And if it were the case,
you're saying the state of Tennessee doesn't recognize taxpayer standing?
It doesn't recognize taxpayer standing outside of a special injury that's not common to everybody in the public, and that's generally either a increase in your taxes, like it was in Lynn versus Polk, or it is the courts have recognized an exception for local services, and both Parks versus Alexander and Fannin, and in Cobb versus Shelby County, the courts specify that they are talking about a local, that exception applies to local policy. So in those cases, to say that those apply to the state would render the court's language superfluous, and any ruling as to the state would at least...
Aren't you referencing locality in those cases because you're dealing with a locality? And if you've got a city and you're bringing a taxpayer standing-based suit against the city, you're going to talk about whether the city has engaged in any illegality. And I'm not going to talk about whether the state is engaged in illegality. Isn't that just tied to the actual nature of the case?
I don't believe that it is, Your Honor, because the court is specifying that this is a disbursement to local government funds. And I think the other thing to remember here is that the prime test, according to Badgett, is whether the person is in a different seat than the rest of the plaintiffs in Tennessee.
That seems to conflate, to me, federal taxpayer standing analysis and Tennessee taxpayer standing analysis. And if we look at Mellon, Frothingham, sort of the foundations of the intertwining of taxpayer standing under federal law, I think that analysis makes sense. But I'm struggling to see why it's applicable when Tennessee has carved out a three-part test for taxpayer standing, where if I'm a taxpayer alleging specific illegality and I've made a prior demand, I don't need any type of particularized injury. Let's assume it's locality, because I understand you're making the argument that doesn't apply to the state. But I don't have any specific injury to me that's unique from anybody else in my city or county, do I?
Well, Your Honor, I think it is still important to recognize that the policy here is to avoid a profusion of lawsuits. So, for example, in this case, you have a plaintiff who's in Shelby County. And under the plaintiff's theory of standing in this case, this one plaintiff in Shelby County could read about the Rutan-Ram's plight in the newspaper and that would be sufficient to create taxpayer standing for that plaintiff.
Tennessee Code annotated 13121 is doing, though, by saying essentially providing a cause of action anytime a person is affected and bringing not a financial claim. I understand legislatures put that limitation in, but if you're arguing something's unconstitutional under 13121, that affected language sounds extremely broad, and it doesn't seem like the legislature's trying to close the floodgates. In fact, they seem to be opening up the door.
Well, again, this court has already recognized in Grant v. Anderson that the affected language is similar to the Tennessee Declaratory Judgments Act. And so I think to read it broader than the Tennessee Declaratory Judgments Act would be against reading the language of the statute. This court has already determined that this is the same language as in the
So the state passed the law that was already the law in the first place.
Well,
and 13121 therefore means nothing.
Well, that's certainly not the case here, Your Honor, because the Tennessee Supreme Court has already said that was a waiver of sovereign immunity. So that would have been a change in the law. But even if on the legislative history that they rely on, the legislature said this doesn't actually change anything with respect to the law.
Okay. You may proceed.
Well, thank you, Your Honor. So I wanted to address quickly another reason why the Rutan-Rams are not injured by the Act is that the Act treats everybody the same under the law. The Act does not create any disfavored classes. It does not even address foster parents. Instead, it only creates an accommodation for religious placement agencies. And this is a religious accommodation that the United States Supreme Court has recognized may even be required by the federal free exercise clause in Fulton versus City of Philadelphia.
So if we're getting into City of Philadelphia analysis, though, aren't we finding our way into the merits of this? I mean, today's about standing, right? Not about whether the Rutan-Rams whether they win their claim or not.
Right.
If we start looking at the City of Philadelphia here, it seems to me that we're getting beyond whether they get into the courthouse door, and instead we're looking at do they actually win their case or not? Isn't our focus a little more limited today?
Well, Your Honor, I think that goes to the question of redressability. Is if they have a federal free exercise, if Folsom has a federal free exercise clause claim, then there's no redressability. What they're asking the court to do is say that do not contract with Folsom under these conditions and under Fulton.
So your reading of the statute is that everybody can discriminate, so there's no violation.
I think that there's no violation from the state, Your Honor, because there, again, for causation, where the courts have been clear, if you're saying that the causation you're alleging is a third party, and that's Thirst versus Wharton and a number of other cases, Lujan versus Defenders of Wildlife, where you're saying that the government's act is being done by an independent third party, and here there's no question that that's exactly what happened, then you have to establish a lot more than just I was harmed. You have to establish why that's connected to the government. And where there's no discrimination announced by the law, it's not enough to just say that there's discrimination by an independent third party, or else you'd make the state a party.
Well, you've got the statute that allows this to go on. So I'm asking you if that statute means everybody can discriminate on religion.
Well, that's again, the question is whether the state is a causal factor of that.
The state passed the statute allowing funding for these people.
Right, but if it was simply enough to that there was allowance, then you would make the state a potential party to any defamation claim because the state allowed the party to make a statement.
Maybe so. I mean, that's for another case, and that's kind of hypothetical and way away from what we're talking about now. The state passed a law that you say allows from what I'm hearing, allows Methodist groups to discriminate, Catholic groups can discriminate, Muslim groups can discriminate, Jewish groups can discriminate, et cetera, for every religion that's out there. And so the state allows everybody to discriminate. So in your view, there's no discrimination.
Well, that's the very nature of an unequal treatment claim, which is what we have here.
So everybody can be discriminated against, so it's okay.
By a private actor.
Allowed to by the state, paid for by the state.
There's been no state-funded services that have ever been denied to the Rutan-Rams.
There we go again. You always come back to that. Okay, thank you.
Thank you.
All right, General Smith, thank you for your argument. Ms. Heibel, your rebuttal.
Thank you, Your Honors.
Have there been state-funded services yet, or will there be, since they are currently fostering a Tennessee child?
Currently, the Rutan-Rams are receiving state-funded services, but
From
DCS, yes. But when they begin fostering a second child, they will again look out at the landscape of available services, and if this court doesn't grant their relief, then they will see fewer
Counsel,
services.
is the funding applicable to the current child they're fostering in terms of recertification and any continuing sort of monitoring engagement? Is the state involved in funding those current services with regard to recertification?
With their current child?
With their current child.
Yes, they get services.
Okay, so even putting aside whether or not they foster another child in the future, you're saying there's state funds that are issued currently with regard to the child they are currently fostering?
Yes,
okay.
Absolutely. A few quick points to respond to the argument, to the state's argument. First, the state focuses excessively on what happened with the Florida child, but that is a red herring. After the Rutan-Rams got turned away in order to foster and adopt that Florida child, they focused entirely on fostering and adopting Tennessee children. On that score, Holston made clear it wouldn't serve them. We make that clear on page 90 of our complaint, and they concede it on page 26 of their brief, where they say that the Rutan-Rams went to Holston for home study and other services in Tennessee. Second, the state argues that the Rutan-Rams are no different from somebody who reads about discrimination in the newspaper. That cannot be true when they specifically went to Holston and were turned away because they're Jewish. And finally, there were questions about how Fulton County affects this case. We agree that is a merits question. It is not relevant here. But even if the court were to consider that question, Fulton is easily distinguishable. In Fulton, the challenged ordinance from Philadelphia had a provision that allowed for discretionary application of the anti-discrimination provision. That's not the case here. There's no free exercise problem.
So counsel, you would classify the city of Philadelphia as falling under the Smith line of cases in the exceptions, accommodations where there is discretion or multiple exceptions that are made, whereas the Tennessee provision has no specific exception. So you would put it in the general sort of Employment Division Smith lesser rational basis analysis. Is that your argument?
Yes, and again, it isn't relevant here when we're not at the merits stage, but Fulton does not change the outcome of this case, even if we're talking about merits. Ultimately, the state says that the challenged act does not discriminate against the Rutan-Rams, but that can't be when they went to a state-funded agency and they were told no Jews allowed. Thank you.
All right, thank you, Ms. Heibel and General Smith, for your arguments. We appreciate and we thank you for accommodating the court and coming to Belmont for this special argument.